Eric Nelson, the attorney for Derek Chauvin, the Minneapolis police officer who's been convicted for second-degree murder, third-degree murder, and second-degree manslaughter in the death of George Floyd, has filed some new affidavits that further illustrate the avenues for attack on this conviction in their push for a mistrial. Now, I mentioned a little while back, and I'll have that video linked, that Eric Nelson is looking to move for a mistrial on several different grounds. One of the grounds I talked about recently was the overall aspect of using the Shepard case to talk about undue media influence in this trial at all stages, both before the trial, during the trial, and after the trial, prejudicial to Derek Chauvin and preventing him from having the opportunity for a fair trial in Minnesota. We now have these new affidavits, which we're going to discuss and talk about how those new affidavits illustrate yet another avenue for that potential mistrial that they are looking for. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer, and I'm also a legal and political commentator on YouTube and on Odyssey. Wherever you're watching, hit the like button, hit the subscribe button, and make sure you have your notifications turned on so you don't miss any videos. Also, if you know other people looking into this case, make sure and share these videos so they know what's going on. All right, into this. So, Eric Nelson is the attorney for Derek Chauvin. As you know, Derek Chauvin was not only charged but convicted of second-degree murder, third-degree murder, and second-degree manslaughter in the death of George Floyd. The other three officers on scene have trials pending, and there's a new update in their case as well, which I'll tackle in a separate video. That being said, the current status is we are waiting on the sentencing of Derek Chauvin. The judge has already released a list of verdicts and rulings in regards to aggravating factors, indicating that he is going to have a higher than guideline sentence for Derek Chauvin, which means he will be facing a significant amount of prison time, and they would have to attack those rulings on appeal as well. But what their goal is right now is to acquire a mistrial, to say that Derek Chauvin was not afforded a fair trial, and there are several grounds for it. As mentioned before, one of the major grounds is the undue media influence in this case. This has been a media circus from the get-go. From the very moment that George Floyd died, the media reporting around it started to skew heavily against Derek Chauvin and had lots of sort of societal pressure going into public officials reviewing the case. There was also some suggestions that media influence may have had some impact on some witness testimony and made it more difficult to procure or even impossible to procure witnesses for the defense, the expert medical witnesses, for example, or use of force witnesses due to the media's influence and the threats and ostracism that those people have received both socially and professionally. Now we have new affidavits being filed by Eric Nelson, and they say some things, but it's really reading between the lines of these affidavits that bring out this avenue of attack. So let's take a look. They're not long. They actually pretty much mirror each other. One is filed by him and one is filed by co-counsel Amy Voss. But we're going to look at Eric's affidavit because it has all of the meat we need for this. So Eric Nelson, first being duly sworn, states as follows. I'm an attorney licensed to practice law in the state of Minnesota and the attorney for the above named defendant, that's Derek Chauvin. On or about Wednesday, January 27th, I received an email from Timothy Arango, where Mr. Arango identifies himself as a reporter for the New York Times. Mr. Arango indicated that he would be in town for a few days and asked me to meet for an off-the-record chat. See Exhibit 1 attached here to and incorporated herein by reference. I responded to Mr. Arango that I am not commenting on or off the record about this matter. On or about January 28th at approximately 12 p.m., I received a call from Mr. Earl Gray, attorney for Thomas Lane, informing me that he had just met with a New York Times reporter and that that reporter had a copy of the state's pre-trial appeal. Mr. Gray informed me that he had read the document, learned that the state was appealing the district court's denial of its continuance motion, and it was to be filed some point that afternoon. On January 28th, 2021, at approximately 3 p.m., the state of Minnesota did, in fact, file their first appeal to the Minnesota Court of Appeals. So this is an indication that Mr. Arango, the reporter for the New York Times, had some sort of insider information, a connection with the state's prosecution office, which would be how he was getting copies of these advance copies of this legal paperwork being filed. Now, on this channel, I have actually covered plenty of lawsuits and have even released documents either contemporaneously or even in advance of them being publicly available. And typically speaking, that's not a huge issue. Where it becomes a huge issue is when you have a criminal trial, when you've got the state prosecution leaking things to the media, and that media has been running a specific narrative about the case, then you start to see some issues, and we see those manifesting here. Let's read on. On or about February 10th, 2021, I received another email from Mr. Arango. Mr. Arango stated in his email that he had learned, quote, that Mr. Chauvin had agreed to plead to third-degree murder, which would have resulted in more than 10 years in prison, but at the last minute, Attorney General Barr backed away. The email went on to provide additional information about the plea negotiations between Mr. Chauvin's prior attorney and the federal government. On or about February 10th, immediately after receiving Mr. Arango's email, I responded, "Thanks for checking. I am not commenting on any aspect of this matter." Later that same day, the New York Times published an article, "Why William Barr Rejected a Plea Deal in the George Floyd Killing." The following day, February 11th, 2021, the Star Tribune published an article titled, "Officials, Chauvin was ready to plead to third-degree murder." In these two articles, as the court is aware, Mr. Arango cites sources with direct knowledge of the plea negotiations and outlines various aspects of the plea negotiations. I am not the source of the information in the above referenced articles. I do not know the identity of the source of the information. Further, your affiant saith not. So this is the affidavit of Eric Nelson, and he is laying out that he is not the source of the information. He is not the source of that leak to the New York Times or the Star Tribune, and that seems to have come from inside the prosecution. So what does this all mean? This means that one of the avenues that they'll be going with is it's a sister avenue to the media influence, because it does directly involve the media, and it involves the media reporting very specifically on a proposed plea agreement that fell through, which was announced prior to the jury actually being fully seated. However, many of the jurors and potential jurors did hear this news or could have heard this news, and that could have influenced their decision on the case. After all, if you're on a jury and you find out that someone was willing to plead guilty to the crime, it's much easier to find them guilty of the crime that they themselves were admitting to committing. And so with this, we now have undue media influence coupled with potential prosecutorial misconduct, as the prosecutors in this case should not have been releasing details about that plea agreement with the New York Times. And specifically, if those details emerged from the prosecution's teams and involved sort of intricate details about the ongoing plea agreement or the details of the plea agreement as they were being constructed, then that type of influence and that type of leak on a matter that should have remained confidential from the state is unacceptable and could certainly be grounds for a mistrial all on its own. When you combine it with other avenues of what's been going on in this case, they have been building a steadily more solid case for a mistrial. Again, in full candor, when he was first convicted and the conviction was first announced, I did not believe they had strong grounds for a mistrial. However, as more and more details have come to light about the prosecutorial misconduct involving the media, about witness intimidation, we're starting to see the puzzle pieces fall into place on why a mistrial may actually occur in this case. I can't tell you what will happen. I can only tell you what has been reported so far and what has come out of the defense team. We are still waiting for the rest of that memorandum, and when it comes out, I will be happy to report on it and give you my full opinion. Until then, Drop a comment down below. Tell me what you think about this. I think this is pretty big news to find out that a New York Times reporter had not only advanced copies of appeal paperwork being filed by the prosecutors, but also seems to have inside knowledge from the prosecution's team about a plea agreement that they had no business knowing in the first place. The prosecution should not have been discussing these matters with the media, and prosecutors in particular discussing ongoing criminal matters with the media leads to things like undue influence, leads to improper motivations in prosecuting, because remember, these types of prosecutions can make political careers for political entities like county attorneys, state's attorneys general, stuff like that. One of them being Keith Ellison, of course. That improper sort of interaction can taint the trial proceedings themselves, and they can taint the ability of the defendant to get a fair trial. And that is the avenue they're going to be taking on all of this stuff, and we will continue to watch. But again, drop a comment down below. Tell me what you think about it, and until next time, peace. Peace.